So Texas, let's take a look at Texas law here, again, from our Texas specific law of self-defense course. I'm going to skip over most of this. It covers, of course, Texas is the one state in the nation that does have a provision for the use of deadly force in defense of mere personal property, even independent of any defensive habitation argument. In every other state, you simply are not permitted to use deadly force in defense of mere personal property, absent a threat to persons or some other independent justification for the use of that deadly force. It is Texas Penal Code 9.42. I'm not going to dive into that today. We have enough to talk about. But if you'd like to read the statute, you can always go to lawofselfdefense.com/942 and read the statute yourself. And I would encourage you to do that because it's important to understand there's a lot of conditions that have to be met to qualify for that statute. And if you fail to qualify, and many of those conditions are based on reasonableness, and reasonableness is not really your judgment of reasonableness. That's not what controls your legal outcome. It's what other people find reasonable, right? The jury, for example. And if they disagree with you, you don't qualify under 9.42 and off to prison you go. But you can find that again at lawselfdefense.com/942. All right. But we're not here to talk about personal property. We're here to talk about highly defensible property. So 2 buckets of property for use of force law purposes: mere personal property, items, your phone, your unoccupied car, stuff, your barbecue outside your house. Then there's highly defensible property. Highly defensible property tends to be property that has as a function the shelter and protection of people. So it always includes your home, your habitation, your dwelling. Often, depending on the state, includes your place of business. Often, depending on the state, includes an occupied vehicle because there's people inside it. That changes the character of the property. An unoccupied car is personal property. An occupied car may be highly defensible property, depending on what state you're in. And it's important to keep in mind that these special provisions that allow for the use of deadly force in the context of highly defensible property, what they're not doing, what they're not intended to do, is allow you to use deadly force to defend that property literally. You're not really being allowed to use deadly force to protect the scuff marks from being put on your door when someone's trying to kick it in, or the shingles on your house, or the antenna on your car if someone's breaking that off. The purpose of these special provisions for the use of deadly force in the context of highly defensible property is that because it is highly defensible property, because it has that shelter and protective function, it's acting as a surrogate for the people inside the vehicle. It's providing an earlier tripwire to privilege the use of deadly defensive force without requiring the normal 5 elements of self-defense in the usual way, because someone's attempting to breach the shelter and security of the people inside. Fundamentally, it's still the people inside that are being protected, not literally the property itself. So Texas helpfully provides some definition of what they mean by these terms: habitation, vehicle. I don't know how much I'm going to dive into those. I don't think I will, because we know it's an apartment, so it would obviously qualify under these provisions. So Texas Statute 931, which we're not showing here, is use of non-deadly force in defense of persons, self-defense, or defense of others. Penal Code 9.32, which is what we are looking at here, is Texas deadly force in defense of persons. So it covers self-defense, covers defense of others, the normal defense of persons, use of force, justification, but it also has special provisions that you might think of as what many states put in separately as defense of highly defensible property statutes. They would have a separate highly defense of property statute that would include this kind of legal presumption we're talking about, which makes it sound like a defense of property provision. But what I've already told you is it's really not. It's really just the property acting as a surrogate for the people inside the property. It's the people really being protected. Texas, appropriately, takes those special provisions, does not put them in a defense of property statute, which would be misleading and incorrect from a doctrinal point of view. It puts them within the defense of persons statute, which is where they should be. So they have the various conditions for the use of deadly force in defense of persons. Let's see, did I even bother putting that here? No. But that's just the 5 elements of self-defense, okay, with the exclusion of avoidance under Texas law. And those are found in, so Texas A2, section A2 is the deadly force in self-defense section. Here, paragraph B begins the special provisions for the use of deadly force in defense of highly defensible property, in this case, habitation, this dude's apartment. And it reads, the actor's belief under the deadly force justification section that the deadly force was immediately necessary. So immediately is imminence, deadly force is proportionality, is presumed to be reasonable. There's the element of reasonableness, 3 of the 5 elements. If the actor knew or had reason to believe that the person against whom the deadly force was used was doing one of several things. Let's take a look at those several things. Now, one of the reasons I say Texas is better than some of the other states we're going to talk about today is Texas explicitly says knew or had reason to believe. There are other states in which a distinction is made between whether or not an intrusion, an unlawful intrusion, was actually taking place in order to trigger this legal presumption, or whether it's sufficient that the defender reasonably believed that an unlawful intrusion was taking place. You can see how that could be a problem, because you can see how a defender might think someone was trying to break in, maybe not on the facts of this case, but you can imagine other facts. Someone might think, and we'll have a case where someone did think that mistakenly. Someone mistakenly thinks there was an intrusion. Now, under Texas law, if they had reason, if that was a reasonable mistake, they had reasonable reason to believe that an unlawful intrusion was taking place, well, then the presumption would be triggered, even if they were mistaken. But if the requirement, and we'll see a state in which this is the requirement, if the requirement is that a reasonable belief of an unlawful intrusion is not enough, it has to be an actual unlawful intrusion. Doesn't matter how reasonable the belief was, then you don't get the benefit of the legal presumption. The jury does not get that instruction. Texas doesn't have that problem because they provide for both. New suggests that there was an actual intrusion taking place or had reason to believe, would simply be a reasonable belief, even if mistaken. So that the person against whom the deadly force was used was engaged in certain behavior. What is that behavior? 1, they were unlawfully and with force had entered or were attempting to enter unlawfully and with force the actor's occupied habitation, vehicle, or place of business or employment. So this part of the statute tells us several things. 1, that Texas has a very broad definition of highly defensible property. Not as broad as possible, but pretty broad. A lot of states would only cover your home, your habitation. The next step would be for a state to cover your place of employment. Often it has to be your business, but at least you have to be employed there. The next step in expansion of the definition of highly defensible property would be a place of business, even if you're just a customer there. And finally, the biggest expansion would be also a vehicle. But in all these cases under Texas law, it only applies if it's an occupied habitation, vehicle, place of business, or employment. So if you're observing your home from outside and someone's trying to break in and you know you live by yourself, your home's unoccupied, well, you could still use force to prevent harm to property, but you wouldn't get this particular legal presumption. Same with a vehicle, place of business, employment, for example. And note also the requirement that the intrusion has to be both unlawful and with force. And I've talked about this before many times. Why require both? And not all states do require both. For some states, unlawful entry is sufficient. But most states that have these legal presumptions of reasonable fear require both unlawful and forcible entry. Why? Because they're concerned about the innocent intruder, someone who's present unlawfully, but not with malice, not with the intent to do anything bad, to commit a felony or harm anybody. And you might be wondering, how can that happen? Well, it actually happens all the time. This happened actually in Dallas. The case of the police officer who went into the wrong apartment and shot the black gentleman who lived in the apartment, thinking she was in her own apartment and he was an intruder, right? It turned out in her apartment that something like 30% of the residents in that apartment building had either themselves, because all the apartments looked so similar, had either themselves walked into someone else's apartment by accident, thinking it was theirs, or had that happen to them. That somebody had thought they were walking into their own apartment and had walked into someone else's apartment. So it was pretty common in that building. It actually happens all the time, especially if there's like out-of-town visitors, right? We've probably all lived in these apartment buildings where they're like completely homogenous. Maybe not to us who live there, but certainly to a stranger who's never been there before. It's not at all hard to walk into the wrong apartment. Or you might be a dishwasher repairman who's given an address and said, hey, the residents can't be there, but they're going to leave the back door open so you can get in and fix the dishwasher. But the address he's given is incorrect. So he goes to the wrong home. Sure enough, the back door is unlocked. He walks in. He's not lawfully present. He's unlawfully present. He does not have license to be in that home. But in all these cases, the person who's unlawfully present is not there with malice. And the state does not want to give the benefit of this legal presumption to use deadly force against the innocent intruder. The with force requirement eliminates the ambiguity. There may be an innocent explanation for why someone's standing inside your front door, but there's no innocent explanation for why they would have broken something to get in, right? So the with force removes the ambiguity from there. And this, of course, applies whether they're already in, they have unlawfully or forcibly entered, or they're attempting to unlawfully and forcibly enter. So this is the first condition that triggers the legal presumption. Or an alternative trigger is that they were unlawfully and with force were attempting to remove someone or had removed someone. So this is kind of a kidnapping scenario.